Assalamualaikum warahmatullahi wabarakatuh. Today, my group will present on topic termination of contract by contractor. I am Harisa and my group members are Nur Aisyah and Arfah Hazira. What is the meaning of the termination in the construction contract? The term termination in construction contracts mean ending the contractor's employment under the contract. Ending the contract between contractors and employer because there is a breach of contract by the other party. Contract is provided for the termination of the contractor's obligation under the contract by employer or the contractor. If there is a breach of contract by the other party, then allow for termination of the contract which brings the contract to end. The contractor has the right to terminate the contract. In certain situations, the employment of the contractor is determined before the completion of the works, but the contract still remains in force to cover the outstanding issues. The contractor is entitled to claim for loss and damages suffered by him due to the termination.
Termination of contract by contractor according to the PWD Form 23A Revision 1 2010. Under version of PWD 23A Revision 1 2010, which applied to government project implemented by PWD, indeed express provision for the termination of contractor's employment by the employer in the event of the specified breach by the contractor of its obligation to complete the works. The relevant contractual provision regarding termination of contract by contractor is clauses 38, which is possession of site, and clauses 55, which is event and consequence of default by the government. Those clauses explain the procedure to be adhered to be in the termination by contractor process, which include the ground for termination, the effect of termination, the financial settlement, and the procedure and condition precedents. The first one is the ground for termination. General causes for termination of the contract include the inability of the contractor to execute the entire or part of the contract, and the refusal of the party to perform the contract at all, or the violation at any other clause of the contract by the other party. The ground for termination by the contractor can be divided into two categories, which is delay in giving site possession and default by the government. Delay in giving site possession. Clauses 38, possession of site. From clauses 38, the contractor is given the right to terminate the contract if there is delay in giving possession of the whole site by the employer and the delay exceeds 19 days. According to the clauses 38.5B, in the event that the giving of the possession of the whole site is delayed beyond 90 days of the date for possession, state in the letter of acceptance, the SO shall give written notice to the contractor of the causes of such delay. Upon receipt of the said written notice issued by the SO, the contractor may inform the SO in writing of its decision within 14 days of receipt of the said notice, either to terminate this contract without prejudice to any other right or remedies that the government and the contractor may be as a result of the termination. From this, it shows that the contractor has the right to terminate the contract in case of delay in giving site possession to him exceeding 90 days. If the contractor is not able to perform any site works or use the site as is necessary to enable him to perform the work according to the contract, the SO has the power to defer the giving of possession of site for whatever reason. However, if the delay in giving possession of the site does not exceed 90 days, the contractor to be granted extension of time, the contractor has to proceed with the works when the site is made available, and the contractor is not entitled to terminate the contract. Default by the government. Clauses 55, which is event and consequence of default by the government. From the clauses 55A, the contractor is given the right to terminate the contract if the government without any reasonable reason fail to fulfill their obligation under this contract. Clauses 55A state that if the government without any reasonable causes fail to perform or fulfill any of its obligations which adversely affect the works, then the contractor may issue a notice specifying the default by the government and requiring the government to remedy the same within the period specified therein, taking into the account the nature of the remedy to be carried out by the government or such other period as may be agreed by both parties from the date of receipt of notice. Meanwhile, for the clauses 55B, the right to terminate the contract, however, should be considered if the government had failed to remedy the default within the period as specified in the written notice issued by the contractor. According to the clauses 55B, if the government fails to remedy the default period specified in such notice issued under clauses 55A within the stipulated period time therein, the contractor shall have the right to forthwith terminate this contract by giving a written notice to that effect. Procedures for termination. The method of termination the contract varies depending on the ground for the termination. The procedural requirement must strictly be followed by the contractor to avoid the termination by challenge by the employer. Clauses 38.5 Possession of site. Under clauses 38.5, if the delay in giving possession of the whole site exceeds 19 days, SO to give written notice of the causes of delay to contractor. The contractor needs to know the reason for delay to make necessary decision later. Next, the contractor to give his decision to the SO within 14 days of the receipt of notice issued by the SO. Contractor has two options, which is to agree to proceed with the works when the site is made available and he cannot claim for loss for damages caused by the delay, or to terminate the contract and is entitled to claim for loss or damage caused by the delay. However, if the contractor does not give his written reply in 14 days, the contractor is obligated to proceed with the work, and he is considered as not taking the option to determine his employment, and he cannot terminate the contractor after agreeing to proceed with the work. Default by the government. Clauses 55 Event and consequence of default by the government. Under clauses 55A, a notice of termination will be given if the contractor decides to terminate the contract after a notice of specifying the default has been issued to the government. The termination can also be subjected to other specifying period if it is mutually agreed by both parties. If both parties agree to allow more time for the government to remedy the default, the termination can only take place after the government had failed to reinstate the default within the specified period. Consequence of termination: default by the government. The contract provides rights and duties of the employer and contractor after the termination. Clauses 55, which is the government shall pay to the contractor, state that the value of the work carried out up to date of termination, the amount payable in respect of any preliminary item so far as the work or services comprised therein has been carried out or performed, and a proper proportion of any such items which has been partially carried out or performed. Next, the cost of material or goods reasonably ordered for the works which have been delivered to the contractor or of which the contractor is legally liable to accept delivery, such as materials or goods becoming the property of the government upon such payment being made to the contractor, and a sum being the amount of any expenditure reasonably incurred by the contractor insofar as such expenditure has not been recovered by any other payment referred to in these subclauses. From this, it shows that the action which are required to taken once the contract is terminated by the contractor, which is the first one, the government has to pay the value of work accomplished by the contractor. Second, the government has to pay the preliminary item. The preliminary item include all temporary building, plants, and material available on site. The amount due the contractor is subjected to the proportionate value of works that have been undertaken by the contractor. And lastly, the government has to pay the material or goods that have been ordered or delivered on site. The material include the property that has not been paid early by the contractor. The government also has to pay for any expenditure incurred by the contractor. The government is responsible to pay for any expenditure incurred by the contractor as a result of the termination. This is because the termination happened due to the government faults. Under clauses 55(2), the contractor is not entitled to get any entitlement for loss and expense incurred due to such termination, such as loss of profit, damages, or other associated claims.
My name is Afra, and I will explain about the determination of contract by the contractor under the Pen Form of Contract 2018. In the Pen Form of Contract 2018, under Clause 26, is described of determination of own employment by contract. In the clauses, it explains the procedure to be adhered to in the determination process, which is include the ground for determination, the process of termination, consequences of termination, and financial settlement. Ground for determination. The ground for determination can be divided into two categories, which is default by the employer or architect and insolvency of employer. Default by employer or architect. In clauses 21.1, the contractor may determine his own employment if the employer default in any of the following, which is employer failed or not able to pay the contractor the amount due on any certificate within the period of filing certificate, employee interfered with or obstruct the issue of any new certificate, employer failed to nominate a succeeding architect or consultant in accordance with the Article 3, 4, 5, and 6, and lastly is the carry out of the work of Section D, the work of uncompleted work is suspended for a continuous period of time exceeding the stated in the period of delay. Based on the above classes, the determinations of contract employment is solely based on the one or more of the following events. For the non-payment by the employer are supposed to pay the contractor the amount due on the certificate within the period of honoring certificate as stated in the appendix. Clauses 13 and 1 stated that the period of honoring certificate is within 21 days after the issuance of the certificate. Any payment made later than the time frame can be considered as a late or delayed payment. Based on clause 13.7, and period of delay stated in the appendix, it can be deduced that the employer will only be considered to have a neglected or failed to pay the contractor if the latter does not receive his payment for a period of 2 to 3 months after the period of honoring the certificate. The contractor can also option for suspension of work for non-payment by the employer. Clauses 26.1b clearly stated that if the employer interferes with or obstructs the issue of any certificate by the architect, it will entitle the contractor to determine his own employment due to the employer defaults. The architect must act impartially in discharging his duty. Next is clauses 26.1c. It clearly stated that if the employer fails to appoint other person as an architect or consultant within the 28 days after the person appointed before is to be the architect, it will be entitled the contractor determine his own employment due to the employer default. And lastly, if there are continuous suspension work longer than period of delay stated in the appendix due to the following events such as issue regarding to the discrepancies between the contract in clauses 1.4 or delay in giving possession of site as stated in clause 31.1 or postponement or suspension of all or any part of work as stated in clauses 21.4. Not receiving AI on times, delay by other person engaged by the employer and appointment and opening of the works for the inspection and testing of work can cause the contractor determine his own employment. These classes set out the ground for determination of employment by the contractor due to the default of the employment or the architect. However, it is not mandatory for the contractor to determine his own employment. It is up to the contractor's discretion to determine his own employment or not. The contractor's remedies are not limited to the determinations. He also may be able to repudiate the contract and sue accordingly. Insolvency of employer. Under the clauses 26.3, in the event the employer becoming insolvent or making a composition or arrangement with his creditor or have paid out under order made or having a liquidator or receiver or manager of his business or undertaking duty appointed or having possession taken by or on behalf of the holders of any debentures by a floating charge or any property comprised in or subject to the floating charge, the employment of the contractor shall be forthwith automatically determined. The contractor's employment will be determined immediately due to one or more of these events, which is employer become insolvent, employer having a winding up order against him, and employer is having provisional liquidator, receiver, or manager of his business or possession taken by creditor or debenture holders. If any of the above events occur, it indicates that the employer has no financial means to carry on with the business. Procedure of determinations. Default by the employer. Clause 26.2. Upon the occurrence of any default under clause 26.1, and if the contractor decides to determine his employment, the contractor shall give the employer a written notice delivered by hand or a registered post specifying the default. If the employer shall continue with the such default for the 14 days from the receipt of such written notice, the contractor may, within the 10 days from the expiry of the said 14 days, by further notice forthwith determine his own employment under the contract, provided always that such notice shall not be given unreasonably or vexatiously. Based on the above clause 26.2, the contract must meticulously read the timetable stated in the contract. It is to ensure that such notice may not be given unreasonably or vexatiously. The step of determination of contract by the contractor that occurs by the default of employer is the contractor will be issued the employer with written notice that have been specified one or more of the event relating to the employer before as stated in the clause 26.1. The employer is given a waiting period of 14 days to see whether he is going to continue in default or not. If the employer fails to neglect to act within the 14 days, the contractor can trigger the next stage of the procedure determination, which is contractor issue another notice to determine his own employment within the further 10 days. However, if the contractor acts with the 10 days of the period, he will lose his right to determine if the employer has resumed the works. If the employer is default within the 14 days, there is no action can be taken against the employer. If the default resumes at any time after that, the contractor has right again to determine his employment within the 10 days after the default occurred. In other words, the employer cannot afford to make the same mistake twice. To prevent the determination process from being abused by either party, the contract includes the following provision, which is such notice shall not be given unreasonably or vexatiously at the end of the clause 26.2. This provision is given to protect employer from being determined for minor default and etc. Insolvency of employer. At the end of the clauses 26.3, it stated that the employment of the contractor shall be forthwith automatically determined. Based on these clauses, the contract can be terminated immediately when any of the events relating to the insolvency occur. The architect can issue the notice of termination without the need to issue early warning notice. In the case of insolvency, the immediate termination is necessary since the contractor is considered as not capable in completing the works. Consequences of termination. Right and duties of contractor after the terminations. Under the clauses 26.4a, the contractor within the 14 days or within such longer period as may be agreed with the writing by the architect, remove from the site all his temporary buildings, construction plan, tools, materials, and goods, and shall give facilities for his terminated subcontractor to do the same. Based on the above clause, the contractor and his subcontractor are entitled to remove all their belongings from the sites, including temporary buildings, plant and equipment, material and goods within the 14 days after the termination of contract. However, material and goods that have been paid by the employer are considered as the employer's property and must not be removed by the contractor in any of conditions. If the contractor cannot finish their works to remove their property within 14 days, the architect can grant the contractors longer period of time for them if necessary, but it's depending on the extent of the work involved. Right and duties of employer after termination. Under clause 26.4b, the employer shall allow or pay to the contractor the total value of work properly executed and the value of material and goods supplied, including any loss and or expense suffered by the contractor caused by the such termination. Based on the above clauses, it can be concluded that it is the obligation of the employer to pay the contractor for the value of the work done by the contractor before the termination of the contract. The employer also entitled to pay the value of material and goods on site and any loss and/or expense incurred by the contractor caused by the termination of contract. The reason why the employer is responsible to pay any loss and expenses incurred by the contractor as a result of the termination because the termination happened due to his fault. Record of works. Under clause 26.5, the contractor shall within the 28 days of the termination of his own employment give a written notice to the architect and quantity surveyor of the date of inspection on site to jointly record the extent of the works. Based on the clause 26.5, the contractor must be issuing a written notice to the architect and quantity surveyor fixing the dates to carry out a joint inspection within the 28 days after the termination of contract. The architect and quantity surveyor are required to participate in the joint evaluation. If the records are agreed by all the parties, it will be the basis for the evaluation of work that have been complete and material on site up to the termination. Settlement of accounts. Under the clause 26.6, is described that the contractor shall within the 6 months after termination of his own employment submit to the employer architects and quantity surveyor for the employer's agreement a final account for the total value of work properly executed, the value of material and goods supply and loss and expense by the contractor caused by the termination. Based on the above clause, the contractor is required to submit the final account to the employer, architect and quantity surveyor within the 6 months after his termination of contract. The final account must consider the value of the work that properly executed, value of material delivered to site including material orders for the works by the contract and also any loss and expense incurred by the contractor due to the terminations including cost of removal from the site. However, if the amount of the final account exceeds the total amount paid to the contractor under the contract, the balance shall be paid to the contractor by the employer within the period of honoring certificate as stated in clause 26.6a under the PAM form of contract 2018. The certificate is binding on the employer and he must make the payment within the period of certificate as stated in the appendix. If it is not stated, the employer must be paid within the 21 days after the certificate. However, if the total amount paid to the contractor exceeds the final contract sum, the contractor is entitled to pay the exit sum to the employer. The employer may recover the payment under the final account from any monies due or to become due to the contractor or from performance bonds or as a debt. Disputed in the final account. In clause 26.6a, if nothing in the said final account is disputed by the employer within 3 months from the date of receipt of the final account from the contractor, the final account shall be conclusive and deemed agreed by the parties. Based on the above clause, the employer is given opportunity to challenge the final account prepared by the contractor within 3 months from the date of receipt of the final account. However, if the final account is not disputed within 3 months after the issuance, the final account is considered conclusive and agreed by the employer. According to the clause 26.6b, the provisions set out the procedure in case of disagreement by the employer to the final account submitted by the contractor, which is within 3 months after receiving the final account, the employer can send notice stating the ground of dispute to the contractor. The contractor will decide to amend or not to amend the final account within the 3 months after the receiving the notice. and after 3 months receiving the amended final account or decision not to do any amendment by the contractor, the employer can refer the dispute to the arbitration, and if not the original final account or the amended final account as decided by the contractor is considered conclusive and agreed by the both parties, the dispute cannot be longer to refer to the arbitration if there is no complaint raised by the employer within that period.
This part will include all clauses related to termination of contract by contractor in PWD and PAM 2018. First is ground for termination. In PWD, clause 38.5B about the delay in giving site possession, and the contractor is given the right to terminate the contract. Then clause 55.0 default by the government. In PAM 2018, clause 26.1 default by employer or architect, and clause 26.3 insolvency of employer. Secondly is procedure of termination. Clause involved in PWD is clause 38.5B, delay in giving site possession, SO to give written notice of the cause of delay to contraction, and clause 58.5B, termination due to default by the government. In PAM 2018, clause 26.2 default by employer, and 26.3 insolvency of employer. For consequences of termination, in PWD, clause 55C default by the government. Actions to be taken by the government when there is a determination or termination in contract. In PAM 2018, clause 26.4, action to be taken by the contractor and by the employer. In PAM 2018 also include the record of works in clause 26.5 and the settlement of account in clause 26.6.
That's all from us. Thank you for listening.